All right, welcome everyone to today's virtual panel discussion on a topic that continues to stir passionate debate nationwide, bail. I'm Liesl Pettis. I'm a criminal justice and civil liberties fellow at the R Street Institute. R Street is a nonpartisan think tank promoting free markets and limited effective government. Prior to my role with R Street, I previously served as a prosecutor, a city councilor, and an executive director for a victim service organization. I'm honored to serve as the moderator today for this important panel. First, some housekeeping. If you have any questions for our panelists, please put those in the Q&A box, and I'll have those read at the end for our panelists to answer. If you're having any issues hearing myself or panelists, please feel free to put those in the chat box or any comments. And this panel is being recorded for you to share later. For the panel, in our society, the bail system stands as a pillar of our criminal justice system, yet it's often shrouded in mystery. Today, we aim to demystify this complex topic and shed light on why bail system changes remain a focal point of conversation. At the heart of this debate lie two fundamental concerns: the need to ensure public safety and the pressing need to address systemic inequities that too often result in unjust consequences for individuals presumed innocent. The tension on how to balance these two pressing needs has sparked fierce discussions on what changes need to be made to improve the system. Yet few know how the system works to begin with. Today, our discussion will be guided by a distinguished panel of judges representing diverse jurisdictions. Drawing on their wealth of experience and expertise, our panelists will provide invaluable insights into the considerations surrounding bail, exploring a range of key topics central to pretrial release. Each panelist brings a unique perspective shaped by their jurisdiction's distinct legal landscape, enriching our understanding of the different approaches to the bail system. So I'd like to introduce you to our judges we have today. First, Judge Tiaiva Bell. The Honorable Tiaiva Bell has served as a judge for the Harris County, Texas since 2021. Harris County has a population of 4.7 million and is home to Houston, which is the largest city in Texas. Judge Bell is currently the presiding judge of the 339th District Court of Harris County and was elected by her colleagues on the Felony Board of Judges to lead the division as their administrative judge. She started her career as a prosecutor in Harris County before moving into criminal defense. Judge Bell ultimately joined the felony trial section of the Harris County Public Defender's Office when it first opened its doors in 2011, where she was entrusted with the office's most serious cases ranging from drugs to murder cases. She also joined the faculty of the Trial Lawyers College, where she taught trial skills courses to attorneys across the country. Judge Julie Kalin. The Honorable Julie Kalin has served as a judge for Jefferson County, Kentucky since 2019. She started off as a district court judge and moved into the circuit court in 2023. Jefferson County has a population of 777,000 and is home to Louisville, the largest city in the state. Judge Kalin began her legal career in 2006 at the Louisville Metro Public Defender's Office. In 2010, she opened up her own law firm with her best friend and practiced for 9 years in state and federal courts, defending people charged with everything from speeding to capital murder. She has tried dozens of cases to juries, and in 2016, she argued a case from jury trial all the way up to the Supreme Court. Judge Kalin has also taught trial practice to both law students and attorneys, and has been a faculty member of the prestigious 2-week Trial Practice Institute hosted by the National Criminal Defense College. Judge Clint Hull. The Honorable Clint Hull has served as judge in King County, Illinois since 2009. King County is the 5th largest county in Illinois with a population of over 500,000 people. Judge Hull started as an associate judge and moved into the circuit judge in 2016. He was elected as the chief judge of King County from 2019 to 2023. After his term as chief judge, he now presides over a criminal call. Prior to being appointed to the bench, he served as a prosecutor for 16 years. Judge Hall was one of 3 judges appointed by the Illinois Supreme Court to serve on the Pretrial Fairness Act Task Force, which eliminated cash bail, along with representatives from law enforcement, prosecutors, public defenders, state representatives, and others. Their charge was to provide guidance and recommendations regarding pretrial reform in the Illinois criminal justice system. Judge Hull was also named the co-chair of the Pretrial Fairness Act Guidelines Committee to develop a model process, guidelines, and related resources for counties to use to implement the Pretrial Fairness Act. And last, but certainly not least, Judge Brittany Schneider. The Honorable Brittany Schneider has served as a judge in Moffat County, Colorado since 2020. The 14th Judicial District, which includes Moffat County and 2 other counties, is a small rural jurisdiction in northwest corner of Colorado with a population of approximately 53,000. Judge Schneider started as a county court judge before moving to district court in 2024. Prior to becoming a judge, Judge Schneider gained experience as both a prosecutor and defense attorney, as well as served as an adjunct professor in criminal law and criminal procedure for the Eastern Wyoming College. Judge Schneider was involved in the creation and implementation of weekend bond hearings for the state of Colorado, and from 2021 to 2023, worked as a bond hearing office magistrate presiding over weekend bail hearings for up to 22 counties in the western part of the state. Welcome, and thank you all for joining for this important discussion. So I would like to start off with a pretty simple question of just what does a bail hearing look like in your jurisdiction? So Judge Schneider, I'm going to start with you. If you could just kind of talk about what it looks like in a rural jurisdiction.
Sure. Colorado recently implemented a requirement for a 48-hour bond bail hearing. And so we have to hold a particularized bond hearing within 48 hours of a person's arrival at the jail. That bond hearing includes the prosecutor and either a public defender or, if there's a conflict, alternate defense counsel. And quite often we're scrambling to find alternate defense counsel to represent a client if there is a conflict of interest with the public defender's office. We go through an advisement of rights, charges, possible penalties, and hear arguments from prosecutor and defense counsel. Those arguments generally are limited. There's not any sort of pretrial services screening, anything like that. So we rely on the argument from the prosecutor regarding criminal history and from the defense attorney regarding ties to the community and reasons for setting a PR bond, personal recognizance bond, or a low cash bond. We do use cash bonds in Colorado, cash or surety. Northwest Colorado uses bail bondsmen, though those are also in limited supply and charge a 15% premium. And so sometimes we have to get a little creative in Colorado, in Western Colorado, especially with the setting of bonds. On the weekends, we do hold bail hearings, and the bond hearing offices that I worked for are designed to serve the smaller rural areas of Colorado. They do have some larger jurisdictions that they serve as well, but they're designed to ensure that folks arrested over the weekend also have their 48-hour bond hearing. So just like during the week, we hold the same type of bond hearing on the weekends, same parties present. And that's about it.
Thank you. Judge Kaylin, I'd love for you to comment on how it may be different in Kentucky, and some of the things that Judge Schneider commented on that I'd love for you to think about too is access to pretrial risk assessments or services to help with your decision-making, as well as use of commercial bonds in your community.
Well, there are no commercial bonds in Kentucky at all. Bail bondsmen have been outlawed for many years. And it's also a crime in Kentucky for an attorney to post a bond for someone, which I think is pretty common. But we have a really, really robust and great pretrial services division. And in all of Kentucky, the way that it works is that as soon as a person is arrested and brought into custody, they are interviewed by a pretrial risk assessment officer. However, of course, like many places, that is an agency that is very low on their numbers of people that they have employed right now. They need more workers so badly. And so many times that is an interview that is conducted by phone, and it's not ideal circumstances. So it's an extremely bare bones overview of the person's prior interactions with the justice system and, what they have provided as far as answers regarding their work situation, living situation, any substance abuse concerns, things like that. So we do get that report very quickly, but it is a really bare bones report that relies mostly upon the defendant's own reporting. In Louisville, because it's such a larger jurisdiction, and to be completely upfront, Louisville is like by far the most progressive jurisdiction in Kentucky. People who are arrested are presented to an on-call judge for an initial bond determination 3 times per day. So that happens really quickly. And then they appear in front of a judge the next morning if they have not been able to post the bond that was initially set but we do not have particularized bond hearings nearly enough. And if we do have them, it is upon motion and with a hearing having been set.
Can you explain real quick just what a particularized bond hearing means for those that may not understand that concept?
Sure. I mean, ideally, if your liberty is on the line, you want the judge to be able to consider all aspects. So that would, as a defense attorney in a particularized bond hearing, what I would want to present is evidence of their work history or employment if they have it. People who can speak and say, I will assist this person, or I will serve as a surety for them, or, I'm willing to make sure they come to court. All of those things are things that ideally a court would be able to consider. And of course, the prosecution would also be able to present witnesses and evidence for the court to consider. It's just a much more information intense overview of a person's situation. And of course, here we have cash bail, which depending on what judge you land in front of, it could be anything from $0 to $100,000. It's totally dependent on the judge.
Thank you. Judge Bell, how does it differ in Texas?
Texas is extremely similar to Louisville, evidently. From my perspective as a public defender, probably got the best look at our bail system. What happens is we have an on-call. It is 24 hours a day. We have 4 settings a day with 2 judges presiding over those settings. The person is arrested. The officer calls into the DA intake, which is also 24 hours. They accept the charges. They take them to the inmate processing center, which is centralized downtown. When they arrive at the inmate processing center, they will be taken up to the second floor. They will have an interview with the public defender that has a public defender on staff there 24 hours a day. They will meet with them, go over the things that they would like for their representation. And then they'll go next to the next window, which is the pretrial services window, in order to have that assessment done. After that assessment is done, they go in front of one of the judges on the next docket from their interview. And at that time, they have a bond hearing in which the public defender represents them at the hearing, and the pretrial service assessment is done. Our county, we've been going through a lot of litigation that's related to bonds, so it is ever changing. I believe last year the legislature enacted SB 6, so in order for the magistrate to set the bond, they have to look at the form, they have to look at the risk assessment, and they have to have a particularized hearing within the 48-hour time period. If the person has not made bond, even if they have, they will appear on the docket in whatever court that they're going to be assigned to the very next day for the judge to revisit any bond and any bond conditions necessary. But the inclination is to put conditions on to address the problems as opposed to jacking up the bond.
Judge Hall, I'd like for you now to chat about what bail hearings look like in Illinois. And if you would also just give a couple comments on kind of pre and post Pretrial Fairness Act of maybe some of the differences.
Yeah, well, so thanks. I mean, and it's really interesting when hearing what they're doing and now what Illinois looks like. This just started on September 18th of 2023, so we're about 6 months into it. Despite what we thought, we're still here and still operating, and but we're learning a lot. A couple things that I just want to, I guess, point out is so we have bond call, or I have to stop that, initial appearance court, 7 days a week. And so we have time requirements on a class 3, class 4, or misdemeanor. So our lower class felonies and misdemeanors, we have to hold those hearings within 24 hours. And on the more serious felonies, we have to hold those hearings within 48 hours, unless the defense makes a continuance request. A couple things that I think are really important that our legislature thought was really important and passed is that our hearings have to be in person. So that was one of the things, especially during COVID, we did a lot using video because of the importance of the liberty aspect. Now everything is in person. That was a huge concern for our rural counties. We have 102 counties in Illinois. I'm right outside of Chicago, so it's a little bit easier on us, but that's been a challenge that we've been facing. Proffers are allowed. So one of the things that we were concerned about was how long these hearings would take. Because we're allowed to do proffers, we really have very few in-person witnesses, so the proffers allow the hearings to go a little bit quicker than we thought. As it relates to the particularized hearings, they have to be. We have to, as a court, we have to make findings, specific and articulable findings based upon the facts of the case. So we have to hear a lot more evidence than we did pre-9/18. And so we have a much better idea of the facts of the case and the defendant's background than we did before. And the other thing is that part of the legislation is to really have an emphasis on the pretrial work. And so we now have an Office of Pretrial Services that operates in about half of the state. But before we ever do hearings, we have risk assessments done. We have backgrounds on work history, on criminal history, and on other things that the court would consider and that we have to consider pursuant to the law. So again, just like she had said, the bond issue, depending upon the judge that was there before, depending upon backgrounds and feelings, you might get a personal recog all the way to a high bond. Now it's just an in or out system. And so I think there's a lot more consistency. I mean, it still depends upon the judge a little bit, but the randomness of the cash bail has been eliminated. And I think everybody's thought that was a real positive experience.
Thank you. And you had mentioned proffers. And so I just want to make sure for people that don't know what that means, generally that means that you can put forward a report or something in written form versus calling a witness to the stand for those hearings. I also saw a comment on somebody just saying that the law works a little bit differently in their community, even though they're in one of the same states as one of you all. And that is completely true. Bond will have some limitations statewide, but will be done differently for each community. And we can try and go over some of those examples, but certainly I know Judge Schneider was saying that she did not have access to pretrial services, but in the larger communities in Colorado, they do. So it will look a little bit different. And we want to get diverse perspectives of rural and urban so that you guys can kind of see all the different ways that bail may work. But thank you for pointing that out to the person that's attending. The next question, I'm going to start with you, Judge Kalin. What are your main considerations when determining bail?
Well, that's a really tough question to answer, not only because it depends on every case, but also because of the ethical rules for judges. I don't want it to be taken as, I always do this or always will rule on this basis. For me, I think probably the biggest considerations are what are the current charges and what is their history of returning to court. But as there have been, movements toward bail reform, not here in our legislature, but locally, there has been a much greater emphasis on determining placement for someone who might be high risk or high needs prior to a bond hearing. And so often when it comes to me, there is a proposal for someone who, maybe would not have somewhere to go otherwise, or has a history of failing to appear related to substance abuse. So that is something that is considered often as well. Is there a plan in place that would give the court some assurance that the person, will be stabilized and in a place where they're able to return to court? But definitely the nature of the present offense is a huge consideration. That said, and I think probably a lot of people that have done defense work on this call will agree, you quite often will have someone charged with an extremely serious offense who has hardly any or no prior criminal record. And, that could be a result of overcharging. It could be a result of a lot of things. So that's something that you really have to temper when you're looking at what they're charged with.
Judge Hall, how does it differ in Illinois or in your jurisdiction?
Well, the new legislation lays out specifically, what we have to consider. And so nature and circumstances of the offense. But I think what's important to note is in Illinois, the legislature dictated what are detainable offenses and what are not detainable offenses. So they completely eliminated judicial discretion in that way, which is a question later on that you've asked, what are some problems that are there? But so if it's not an offense that's detainable, no matter what the history is, no matter what the failure to appear rate is, that's not somebody that we can detain. On the offenses that are detainable, we look at the nature and circumstances of the offense, obviously. but then we're also required to be able to cite with specificity how they pose a real and present threat to either an individual person, persons, or community. It's not enough to say, well, they're charged with aggravated discharge or attempt murder. You have to elicit exactly what it is about that makes them a risk. And then really where a lot of the litigation is happening is then we also have to be able to show that there is no condition or conditions that would mitigate the threat of the safety concern. And so that's where a lot of the appellate litigation is occurring because, for instance, like on an ag DUI, we may want to consider, that a person driving drunk is obviously a threat to the community or whatnot, but there's a way to mitigate that, which is to order them not to drive or to put them on a SCRAM device that monitors alcohol or a BAID device, which makes them blow into it. And very hard for anybody to argue that that's not a condition that could mitigate the threat. So the legislature has dictated to us exactly what it is that we have to find, and the evidence that we're being presented with are on those three factors.
And we will dive into what can help mitigate some of the risks in a bit. So I would like to just tag that all for you, just how different it is, what can be preventively detained in your states, as well as access to things like a SCRAM unit or electronic monitoring. Judge Snyder, how is it different for you in Colorado when you're determining bail?
So in Colorado, much like in Illinois, it sounds like there are certain things that we are to consider when setting bail. It's statutory. And we start from the presumption that all persons are eligible for release on bond with the appropriate and least restrictive conditions. So we consider the same things that Judge Kalin was talking about: the charge, history of failures to appear, ties to the community, any indications of flight risk. When available in Colorado, you are required to use an empirically developed risk assessment instrument, I think is how the statute puts it. And when those are available, judges are required to use them. Again, they're not readily available to me in Western Colorado, in Northwestern Colorado. Family members who are available to help, prior criminal history, if I didn't say that. And really, the idea is weighing all of these factors, determining whether the person can be safely maintained in the community, and whether a monetary condition of bond will help do that. There are,
sorry, go ahead.
There are a couple of low-level offenses that require a PR bond in Colorado, absent some small exceptions.
Thank you. Judge Bell, what about for you in Houston?
Ours is governed by the new SB 6. So it's kind of like Illinois and Colorado, they kind of lay it out. We look at the nature of the offense, and as it relates to that, if it's a crime involving family violence, or if it's involving violence, or if it's involving violence towards an officer, the ability of the person to make bond is one of the things that you get to take into consideration. You have to also look at the future safety of the victim or the community as it relates to any bond. You look into criminal history, any criminal history that's available, and also looking into any bond forfeitures or anything that would seem to indicate the person would not appear in court. And the new one is they also look into citizenship in order to make a determination as to whether the person is eligible for bond. Those are the things that statutorily are laid out that you have to take into consideration. It does start off with a premise that all people are entitled to bond unless it's one of the excluded. One of ours don't have necessarily per se a list. In capital murder cases, if the state files a proof evident hearing and shows that there's a great they're probable to make the case, and if they make the case, the jury is likely to give death if asked, then those are the cases that we can hold at no bond. Or if you have a situation where someone is on bond and picks up a new offense, if the state has a hearing, an 11B hearing, and shows that they violated a condition of one of the bond conditions and it was related to community safety, those were some of the other cases the person can be held at no bond. But ours is pretty much laid out. They didn't give us a list of ones we couldn't do bonds on, but what they did is they limited our ability to get personal bonds on a certain range of cases. and there are misdemeanors that, based on the lawsuit and the consent decree in Harris County, which is different from Tarrant County, there are a list of the ones in Harris County that are based on the consent decree, based on the lawsuit, that the O'Donnell lawsuit that was filed here years ago. There are a list of misdemeanors that are automatically qualifying for personal bonds. But we do bondsmen, and that's a whole hot mess.
And I'm actually going to bounce right back to you, Judge Bell, to talk about the use of cash bail. And I think this is such an important piece, because really bail has a lot more to it than cash. There's other conditions that you guys have all kind of talked about when somebody's released. But cash bail seems to be the one that people talk the most about. So can you just talk about your use of cash bail in your community?
The use of cash bail in Texas is heavy and is prevalent. And the reality of the situation is, after the O'Donnell lawsuit, where the misdemeanor, the basis of that lawsuit was there was someone that was in there for a driving while license invalid. It was a traffic ticket with a twist. The bond was set at $500. The person didn't have $500 to make the bond. They didn't have any resources. So on a driving while license invalid with no accident, the person was held in custody. They stayed weeks in custody. So a federal lawsuit was filed. When that lawsuit was filed, one of the determination is, if there's no safety risk, we're going to come up with these list of cases that allow for the people to be bonded. The bail bond industry sued the county because they thought they had the right to make money off the people on these bonds, and because they lost a lot of money when these cases came into effect. We have just had our last legislative session. When the pandemic had hit and the bail bonding industry was losing a lot of money, they went from taking a 10% down payment on these bonds to, in some cases, 1 or 2% or payment plans for murder cases. So you could set a bond at $100,000, but they got to pay $10 to get out. They're just good and out. It doesn't do anything to kind of put that assurance there that you are putting that tool there. I kind of really love the Illinois system. Either you are in or you are out, but we haven't made that kind of progress in Harris County and or Texas yet. So if you can get the money together, then you can make bond. And we have a whole litany of cases that are coming up in Harris County where people are committing crimes and robbing people to get their bond premium. So for the friend, so they could get the friend out. And when our bond policies are creating more crime, I think it's kind of problematic.
Interesting. Judge Kaylin, I assume it's fairly similar in Kentucky with your use of cash bond. Can you describe a little bit how it looks for you?
Yeah, I think Judge Bell and I probably have a lot of seeing eye to eye on this issue. I also wish that our system mirrored Illinois, or really the federal system, which, having done federal criminal defense, I got to know that system, and it has its issues, but it is, in my opinion, very preferable to the cash bail system, because in Kentucky, truly what happens, as Judge Bell was saying, is if the judge doesn't want you to get out, they just set your bond very high. And the issue is, if you turn out to be a rich person or know a rich person, that does not matter. And in fact, quite frequently, we will see things like a $1 million bond with zero restrictions, because they just assume that the person's never going to be able to post it. But if they could, then they're out with no monitoring, no conditions of supervision. I really appreciate that Illinois, like the federal system, has the standard of requiring that there are no conditions that could be placed upon the person that would ensure, that any risk to the community could be mitigated. I really like that a lot about the federal system. But in practice, what we see here in Kentucky, as I said earlier, is that it is going to be completely dependent on what judge you happen to land in front of that day, which could be based on your last name. It could be based on somebody had to switch schedules with another judge. It is really, truly dependent on that. And it is in no way, in my opinion, just or fair.
Judge Snyder, what about for you? And I would love for you to kind of work into that as well, your lack of availability to alternatives to cash bail, as you mentioned earlier.
So cash bail is used very similarly to how Judge Bell and Judge Kaylin indicated in Texas and Kentucky, but practically what we find, especially in rural Colorado, is that there's not an alternative. I don't have a scram unit to put on somebody because we have a limited number of scram units contracted out by a private company, and most of those are being used for our probationers. And so we don't have a pretrial services program in the 14th Judicial District. There are some robust pretrial service programs in Colorado, but unfortunately we don't have that benefit. And so when we're looking at cash bonds and cash or surety bonds, we're also limited on bail bondsmen. And as I mentioned, I think earlier, they're charging a 15% premium. And so a lot of people can't meet that. What we find ourselves doing is trying to set a creative bond, sometimes a low cash bond that we think will ensure appearance as low as $50, saying put some skin in the game so we know you're going to come back. And we're going to set every creative bond condition that we possibly can for you, whether that be testing several times a week, whether that be signing up for our text message reminder program, those kind of things. But it is a real problem in rural Colorado because you have this cash bond system. A lot of folks who can't afford to meet their bonds. So you find yourself considering people's employment, you find yourself considering people's ability to pay, and you find yourself reconsidering bond quite frequently in an attempt to not keep people in custody simply because they're unable to pay.
Judge Hall, you may have the easiest answer to this, but cash bond in Illinois.
Yeah, I mean, it's crazy to say. I mean, so September 18th, there is none. There's been some really big hits on that because we used to use that 10% to fund, the government would get 10% of that. So we would fund salaries and all sorts of things with that. So the fact that there is no cash bail, there's an impact that we're feeling on that end. The only thing I would say is prior to September 18th, you can imagine the number of cash warrants that were issued that were outstanding prior to September 18th. They go back decades. So the issue that we do have is when somebody gets picked up on a pre-September 18th warrant where there's a cash amount, we have to look at it to decide, number one, is it a detainable or non-detainable offense? And then the way it's kind of working in our jurisdiction, it's a choice of law. So does the defense want to choose to go under the old system and post the cash, or are they availing themselves to the new system? And so that's really a case-by-case basis. But so we're still accepting cash. We have two sets of forms, pre-918 forms and post-918 forms. And as time goes on, we'll get rid of those pre-918, but there'll be warrants, cash warrants, that'll be outstanding forever. I mean, just people get picked up and we have to go through that.
You hit on that the courts or the system were keeping 10%. So I just want to note that in states that generally have commercial bond, when you work with a bail bondsman, that 10% goes to the bail bondsman and is generally non-refundable. So the bail bondsman gets to keep it. But there are states that don't use bail bondsmen that the court essentially works in that way. And I assume that's what you were referring to with Illinois, that they were keeping that 10%.
Correct. About a $500,000 hit to our county just in a year. Then Cook County, which is the biggest, you're talking about 10 times that.
Judge Hall, I'm going to go right back to you. We often hear concerns about public safety, repeat offenders, failing to show up for court, these kind of pressing issues that people are concerned about when it comes to pretrial release and bail. And so as a judge, how do you try and address these key issues in your bail decisions?
Well, I mean, they're definitely, I mean, we're learning every day. One of the biggest concerns was failure to appears. If somebody is arrested on a non-detainable offense and they don't come to court and we issue a warrant and they don't have to post, how do we keep them appearing? That's happening. I'm seeing that in the courtroom that I'm at. I have people that have been arrested. They come in, I give them a date. They don't show up. We're not supposed to issue warrants, especially on lower level offenses. So we issue a summons. That summons comes back. They don't show up again. I issue a warrant. They get picked up on the warrant. It's a non-detainable offense. I have to release them, and we're in a repeat cycle. And in the bail system, right or wrong, at some point when that person failed to appear enough times, there was a high bond that was set, and that case ended up getting resolved. That's not the way that it's happening. So we're learning. That's definitely one of the issues that we have. Another example that I had just this last 2 weeks is I had a gentleman that was before me arrested on a driving while license revoked based upon a DUI. It was a felony because he had committed that same offense between 4 to 9 times. It's a non-detainable offense. I would have set a bond on him and a high bond because he just continues to violate. Interestingly enough, here in Illinois, again, no judicial discretion. So if the state doesn't file, even if it is a detainable offense, if they don't file a petition to detain, doesn't matter how I feel about it, there's nothing the judge can do. In this case, nobody could do anything because it's a non-detainable offense. 8 days later, surprise, surprise, guess who's in front of me again on another driving while license revoked. And the only thing that I would say about our system, and one of the challenges that we're having, but the legislature provided, is they do give the prosecutor and the court the ability to revoke pretrial release, and even on offenses that would otherwise be non-detainable. So when this gentleman came in front of me after being on pretrial release, they were able to file a petition to revoke, and I was able to grant that. But there are challenges that have been out there, and some of those things are very well, we're seeing them and we're experiencing them, and we don't have an answer right now. And it's one of those things where we just have to be optimistic enough to know that there are things that we'll be able to, I hopefully, solve as things go on. But there's issues, and we're running into those issues.
Can you chat about, considering the fact that you don't have access to cash bail, some of the other conditions that you might use for making sure that somebody is going to appear to court, or that they hopefully will stay law-abiding, that you would use outside of detention?
Well, I've seen each one of the judges and the panelists talk about this. I mean, what we've really tried to do, and again, this is geographic, because there are areas, I'm in an area that has a lot of resources. If you were to have a judge from Illinois, from Central or Southern Illinois, I don't think that they'd be nearly as smiley about this as I am, because they don't have the same resources. And so we have a really robust pretrial services department. We can put them on conditions. We can make phone calls. We can do text messaging. We have electrical monitoring. If we want to really up our level of supervision, we have that ability. Again, we can't do it on any case. It has to be specific and articulable as to why we believe those conditions are necessary. But down in Central and Southern Illinois, where they don't have those same resources, that's a real problem. And so on our end, like that gentleman with the driving while license revoked, I put him on the highest level of pretrial. I ordered that he not drive. I ordered that he, but the conditions are only as good as the person's willingness to follow them. And in those cases, he's not going to follow them. So that's how we do it. But that's really, I don't think, any different than what we had with cash bail. It's just that the ability to address that is a little bit harder under our system now.
Judge Kalin, I would love for you to comment on this as well. And if you could also, while you're speaking, talk about your ability to preventatively detain, the conditions, but then also revocation if needed of a release.
Yeah, I'm actually dying to know from Judge Hull if that person that you were just referring to as an example, if that is someone whose pretrial release could be revoked, what status would they have then? Would they then get a bond, or would they then just be detained?
No, and so now that person, based upon the statute and the revocation, even though it was a non-detainable offense, they're now detained, no ability to post cash.
Okay.
So they're there. So the upside is that he's there. The downside is he broke the law a number of times to get there.
Yeah, that'll probably get resolved pretty soon. That's interesting.
Yes.
So I'm so sorry. Would you mind to repeat the question?
Yeah, just what do you use? I mean, one of the biggest concerns right now in the bail discussion is what happens with repeat offenders, people not showing up for court, public safety. So what is it that you do to kind of try and address those issues? And in answering, if you could talk about some of the differences of what you can actually do for preventative detention, where you're detaining somebody with not worrying about cash bail, as well as what you can do for revocations, if that's an option too, as well as other conditions you may use.
Yeah, so when a person comes, and I'm in circuit court, and in Kentucky, we have, district court and then the circuit court above it. But many times felony cases will begin in district court and then come up to circuit court. And so by the time it gets to me, it has almost always had some bail determination at the district court level. And so at the initial appearance, I will review their pretrial report, where the bond has been, how they've done with the bond, where it's been. Those are all things that I consider. But a condition of bond is always come back to court and do not get charged with any new criminal offenses. Those are always conditions of bond in my court, even if your bond is that you are released on your own recognizance. So if it comes to my attention that the person has picked up a new charge, or, they don't come back to court, I can, of my own volition, or the prosecutor can move for a hearing revoking their bond. However, in Kentucky, by the state constitution, everyone must have some cash bond unless you are charged with a capital offense. That is the only circumstance where we can say, no, there's just no bond that you could post. So even when I find that there has been a violation of bond, I still must set some amount of cash bond. The options that we have available to us are growing as far as electronic monitoring, home incarceration, that kind of thing. The issue is it's still nothing like what we have available in federal court. Federal court is just such a number-wise smaller system. They are able to provide much more intensive monitoring and do things like, we're going to come in your house and make sure you don't have any access to the internet and things like that. More intense reporting or supervision at the person's home. All of those things that you see more in federal court are just not available because of money reasons, really, in the state court system, which is unfortunate. But, when I think about that, I think, well, perhaps if we had a system in state court of no cash bail, we would stop seeing quite so many cases brought on not serious charges, which I think could be a beneficial side effect. There's just way too many cases in the state systems, in my opinion.
Judge Bell, can you tell me how it may be the same or different than kind of what you've heard from Judge Kalin and Judge Hull?
I think it's similar, but I will say that because of all the litigation, there are a number of conditions that in Harris County I'm able to use. If I'm in a situation where I have some concerns, I can give you a GPS monitor that you don't have to pay for and put you on 24-hour home confinement. And if you move your little butt out that house, I'm going to know. And then we're going to send these people to your house to come and get you and bring you back so we can have a conversation. If it's a situation where it's a possession of child pornography case or a trafficking case, I can add a condition that you put a pin registry on your phone in order for it to, and it's not your phone, every electronic device that you have in your home. So I don't have to worry about you surfing the internet, because it's going to send to the DA's office and to your attorney these sites that you're looking up. And if they're a little bit suspect, then you're going to be back and we'll have a conversation, because if you're doing it, then the first condition that Judge Kalin said, no new offenses, no community safety, and one of those for the porn cases, no porn while you're on my bond, or no child pornography while you're on your bond. So there are a number of conditions that you can put in place to tailor your concerns specifically to what the issue is as it relates to that particular case. And it does allow for us to do something different on the bonds or do a lower bond number so we can address concerns elsewhere, but there's still some of the same problems. I can't guarantee that you're not going to get you a track phone and start looking up stuff on the internet. There's no way for me to make that determination. And then you have the instances where people just decide they're going to commit their crimes with their good old GPS monitors on, or cut those suckers off. So, I mean, those are still issues, but I do like having those conditions that I can put in place to try to look out for public safety.
Judge Snyder, you probably have a ton of envy right now hearing about all these options in a rural jurisdiction. But tell us how you try to, really work on addressing public safety, kind of this revolving door into the system and failures to appear.
So the public safety and the repeat offenders issue is the ones that keep me up at night. And really, we put in place a protection order in every case charged under the Colorado Criminal Code under Title 18. Protection order, at least, that says don't harass is required. And I am very careful when I set those protection orders to be very particular about what I expect of anybody who comes in my court. I am lucky in some ways because I have time to hear from the victim and a lot of time to hear from the victim because my docket is just not as frantic as I expect my colleagues' dockets might be. So I get input from the victim, I get input from the DA, from the PD or the defense attorney. I put in place the protection orders. But again, no EHM, no GPS monitoring, no pretrial services, no watching. I try to keep people coming back before the court pretty frequently so that I can keep an eye on sort of the pulse of things. Because I do think if we keep the case moving, that helps with the community safety concern if they know that they have to come back before the judge. But we really are limited in that area in northwestern Colorado. Interesting thing with failures to appear, and I don't have the data on this is sort of anecdotal my experience. We adopted a lot of WebEx appearances during and post-COVID. We're still using WebEx for court appearances. I've actually seen a decline in the number of bench warrants I issue for failure to appear. People are appearing because they have the ability to appear remotely. And so that's why failure to appear is not nearly as much of an issue for me as the other two, but the other two are a big issue.
Thank you. And I saw a question in there about Kentucky and their only ability to preventatively detain somebody. And what I mean is like there's a hearing and they will be detained. There is no option to bail out. And that was only for capital offenses. And I just want to comment, yes, you heard that right. And actually several states have that model. Colorado has a couple other offenses, but it's very limited. Most states, it is just capital offenses. And with the recording that we will send out after, we will also send out our recently published paper comparing state by state all the bail laws, which include what can be preventively detained, how quickly a bail hearing needs to be had, whether or not there's pretrial services or risk assessments, so that people can use that as a resource as well. Going into the last question here, and I do see several questions for you guys from attendees, so let's try and make this a little bit quick so we can get to some of those other questions. But this is more just an open question to you of what do you believe are some of the biggest challenges with the current bail system in your community? Again, they're all different, so you probably all have different challenges. But I'd like to start with Judge Bell. What would you say is one of the biggest challenges?
That we don't use the federal system or the system they use in Illinois. Cash bail is a problem, and you shouldn't be in custody because you can't afford to pay it. You should be in custody because we can't trust you out in the streets. So I just think that the cash portion of the bail is the biggest problem we see.
Thank you. Judge Snyder, what do you think?
I think Judge Bell hit it on the head. And in Colorado, we have actually the added issue of we don't do proof evident presumption great hearings on capital offenses anymore because we don't have capital offenses. But what that resulted in for Colorado was a lot of no bond holds that were no longer considered legal. So a rush of judges trying to set bonds in those cases where they were previously no bonds. So we're not setting no bonds in capital offenses because we don't have capital offenses anymore. I think that the legislature is going to clean that up eventually, but that's an issue facing Colorado right now. But really, we don't have an overcrowding population issue, jail population issue in northwestern Colorado, but we are, even inadvertently probably housing people who are in just because they can't afford to pay the bond, and that's a real problem.
I'm going to note on your capital offenses comment real quick because Colorado's not the only state that had that issue, but capital offenses are offenses that face death. So oftentimes it's going to be your first degree murders. And if a state no longer has the death penalty, it means that a first degree murder is now just a life sentence versus death, which that's what Judge Snyder was saying. It's in the state of Colorado. Those first degree murder charges can no longer be preventively detained. That is not an option because of this kind of change in the law. And you guys are not the only state that kind of have that issue, but I want to make sure people understood that. Judge Hall, what are some of the challenges? And I know you actually mentioned some earlier, but what are some of the challenges that you're facing in this very new and different system of bail?
A couple things just before I do that. I do want to know when you were talking. So in my county, we've seen our jail population drop by about 130 people. Yeah, and so, you know, one of the things that we've noticed is, again, as the judges had said, before people were being held and it was just whether they could pay or not pay, that's been eliminated. And so we've seen a direct correlation to that. But challenges, one is 102 different counties, 102 different elected officials, 102 different approaches. Our state's attorney is very open to new ideas, and but there are other counties where they're filing petitions on every case. And so there's a lot of, again, just depending on where you get arrested. If you get arrested on this side of the county line, you may be treated one way, and on the other side of the county line, not different than the other system. The lack of judicial discretion in Illinois is really, really frustrating. The legislature, I think the feeling is maybe they don't trust us. So they're not going to give us the ability. There are some cases where even if it's a low-level felony or a nonviolent crime based upon the history, based upon the other information the court has as it relates to substance abuse or whatever else, it may be appropriate to detain that person, but that's been taken away from us. So that's a real issue. And I think the most important or the biggest challenge is funding. Again, they've said, and the legislature has said, you have to do it in person. You have to have it within this period of time. None of those things are bad things, but then you need to have the resources to be able to do that. You have to have the number of public defenders in rural counties. The chief judges in rural counties said we have 1 or 2 people that are supposed to cover 100 miles. And we have to, and we don't have enough attorneys. We can't afford to hire attorneys. How are we supposed to deal with that and comply with the law? And so I'll never forget one chief judge saying, I am never going to say that we're not going to follow the law. We have an obligation to follow the law, but what happens when I can't? And without the resources, you're really putting people in a trick bag on that. So I think that funding and trying to find, these are all great ideas and then things are working. But if you're going to do it, you have to back it up by giving the appropriate funding to be able to allow the court system to do what they need to do.
Thanks. And Judge Kalin, what challenges are you seeing?
I think in Kentucky, our biggest challenge is public education, really. Getting people to understand the complexities of the bail system. I know that there was a question in the Q&A that I saw reference this, but we are elected in Kentucky, judges are elected, which I don't think is a bad thing at all. I like being accountable to the public if the public is voting for the right reasons for someone and not just because they like their last name or saw more commercials from them or something. But there are a lot of judges who became a judge not because it was their passion, but because it was a thing that they thought they would try their hand at and had the money disposable to them to do it. And they do not want to lose their jobs because for many of them, they might not have a practice that they previously engaged in that they feel comfortable returning to. They're not really quite sure what they would do if they weren't a judge. And because they're so worried about losing their job, they err on the side of keeping everyone in who might put them in the news. And that's a really big problem, is getting the public to understand that judges do not have crystal balls, that the answer is not to lock everyone up. We cannot do that. We cannot afford to do that. Financially or for societal reasons, we cannot afford to do that. But that is a huge part of it, because without that, I think we will continue to have judges act out of fear of public scrutiny instead of for reasons that, are fair and follow the law.
Thank you all for this great discussion. And we had several great questions. So I'm going to do a little just raising your hand on some of these, but talking about who's elected versus appointed. Who here are judges elected in their state? Okay, so everybody but Colorado. And thank you for going into some of those pros and cons of electing somebody. That was very helpful. Wondering, is anybody using AI to help determine bail bonds? None. Okay, interesting area to explore. We have somebody here who's asked, sorry, there's a lot of questions, so trying to read through them. In your respective districts, approximately how many people appear for bail hearings per day or week? And I'll just go around real quick. Judge Bell, if you have an idea, an approximate. And it's okay if you don't know.
Approximately we have 2 calls 4 times a day. They generally have about 30 people on them a day. Me and math never really got along. That's why I'm here. 30, 60, 90, 120. 120 times 2 is 240. So 240 4 times a day for whatever that number is. That's about how many we have.
Judge Caitlin?
I'd say it's probably about 60 a day for initial determinations. And then for actual full bond hearings, I don't know, maybe 30 to 50.
Judge Hall?
We separate them into 2 different things. One is the non-detainables. We call those condition hearings. There's probably about between 25 to 30 every morning. On the detainables, those are actual hearings. Those are in the afternoon. We range anywhere from 3 to 8. We have some that are less and some that are more, but that's about where we're at. 7 days a week.
Judge Snyder?
I'll give you a range. It's somewhere between 0 and 15 for the district on any given day. And just to give sort of a broader idea, when I was doing weekend bond hearings for 22 counties, we'd see about 18 or 19 per weekend day.
Thank you. This next question, oh, sure, Judge Caitlin.
I just kind of wanted to briefly mention Judge Hull had talked about judicial discretion and how it can be very frustrating when judicial discretion is taken away by the legislature because every case truly is unique and different, and we should be able to judge them based on those differences. However, the flip side to that is that there are some places where we are not going to see any sort of significant change in our numbers of those we are jailing without taking away some judicial discretion for the same reasons I was just talking about, where judges are operating out of fear in many cases of public scrutiny. And having the legislature take judicial discretion away in some of those instances would give them a cover to, operate more liberally.
All right, we have only 2 minutes left, so I'm going to throw this one out to whoever wants to try and answer it. But somebody asked, how can you all work to expedite the wrapping up of these cases so that FTAs are less probable, particularly for low-level offenses and cases that should not be complicated? Does anybody want to try and tackle that? Sure, Judge Caitlin?
This is something we're currently working on in our jurisdiction. In district court, it's another thing, but in circuit court, there's been this pattern I've noticed over the years of, okay, what's going on with the case? All right, let's pass it 6 to 8 weeks. We'll see you then, which does not make sense if the lawyers are sitting there saying, we've got a bunch of discovery to do. We need to have meaningful conversations. So I think one of the things that judges should do or try to do, and I'm sure most of the panelists here do this, is say instead, how long should we pass this for you all to get done what you need to get done? And at the same time, monitor, and I think most judges get a sense of the attorneys before them and who's maybe malingering on a case or not, but pushing the case forward, but also not having all of these court appearances unnecessarily.
Love that. We actually have to wrap up now. Just for the attendees to know, we will be sending out the recording. We'll also send out some additional resources that hopefully will answer some of your other questions. But feel free to reach out to us to ask some of those questions. I can certainly chat with the judges and see if they have some answers to provide. But we appreciate everybody attending today. And huge thank you to our judges that participate in the panel. Thank you.